Morning, Marshall. How are you?
I was worried you're spiking my water. You know the answer to that.
could almost shake their hand.
Yes. I have one there before the new building.
Oh yeah, I haven't.
And of course, this will all be different. This case would have gone to the new 6th district.
Really?
Yeah, we're going to be in the 6th.
You know, I was on that committee.
Mm-hmm.
Yeah, it was interesting.
Yeah, we've always felt like we were the redheaded stepchild. The second now will be the redheaded stepchild. Number 6.
Now I forget, but I think is Lakeland going to be in the 6th?
That's right.
And that's because they've already got a courthouse.
Well, I know. I've been in that courthouse many times.
Yeah, me too.
The old Citrus County. Yeah, was it the Citrus
Oh,
County?
Citrus Canker?
Yeah, it was just the courthouse. The courtroom itself was pretty fun. The building was obviously quite old.
Yeah, the building's pretty old. Yeah, but still doing Stetson, right?
Yep. Which is, I haven't done an oral argument in Lakeland, I bet, in 8 years. Pretty much all the 2nd district, right? Hadn't been happening. Because that's where everybody lives. It's like 3 blocks from our Tampa office.
Oh yeah.
Hey, something might come down. The Justice Rosemary's husband is, most of it is construction insurance, a third party. Her husband's one of the best construction practitioners in the state.
Oh yeah.
We have some joint cases, we have cases against each other. He's very good.
Oh, that's good.
And he's committed to what we were talking about earlier. He's very committed.
You go to the restroom before we start.
For the first time ever.
That would be
On
terrifying.
the floor, on the fly.
Court of Florida is now in session. All we have cause to plead, draw near, give attention. You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to this session of the Florida Supreme Court. The first case on today's docket is Westin Property and Casualty Insurance Company versus Riverside Club Condominium Association. Counsel?
May it please the court, Raul Cantero for Westin Insurance Company. This is an appeal from an order compelling appraisal in a case in which the insurance company denied coverage. There's a recognized and certified conflict in the districts about whether when the insurer denies all coverage for a loss, appraisal is appropriate.
Can I stop you there, Mr. Cantero?
Yes, sir.
It's not right to say that this insurer has denied all coverage, right? That's just factually wrong. They advanced $500,000 immediately after the incident. They pay out a little over $4 million to date. There's been no effort to claw that money back. How is it factual to say that they've denied all coverage on those facts?
Because, Your Honor, what happened was the hurricane occurred in September 2017. The insurer advanced money before it had completed any investigation and before the misrepresentations had occurred.
Okay.
So at that point, no misrepresentations had occurred. There was no basis to deny coverage.
I'm with you so far, but there's a basis today, right?
There was a basis in November of 2018 when it finally denied coverage because of the misrepresentations. So what you're suggesting is no good deed goes unpunished.
No,
we have to claw back that money now.
What I'm suggesting is it's not factual to say that all coverage has been denied when we're at T plus 4 years from the payout, and you're not here representing to us that there's been any effort to unscramble that egg or to try to reclaim that money. So if that's, and I realize how much hangs on this. Your position is that since you've denied all coverage, then there's no appraisal that's appropriate at this time. But if we're just being factually honest, there's been no effort to claw back the coverage that was already advanced, and that, I think, does color whether or not an appraisal is in order.
Well, Your Honor, again, eventually the insurer did deny coverage and say we advanced 10% of what they're now claiming is owed. I mean, there's $37 million that they say they're in damages where we have denied coverage on. So I believe that it is accurate. It's accurate to say both, okay, that we initially provided those funds when we didn't know the actual facts. We knew that a hurricane had occurred. We knew that there was damage, frankly, from the hurricane, not even close to the extent that they say, but they never said there was a waiver of deny of coverage because we did not claw back.
There couldn't be a waiver based on something you did before
right.
Their misconduct, the alleged misconduct.
Agree.
So have they ever claimed that there's a waiver because you didn't claw it back?
Yeah, well,
Is that what they're saying?
They argue in their answer brief that they don't go through the elements of waiver, but they said they never tried to claw it back, which, frankly, I don't think that's relevant because we eventually denied coverage. And the issue is now, where we have denied coverage under the policy, yes, we haven't clawed back what we paid, but we've denied coverage for anything that they're claiming after we discovered the fraud. Now, whether we have to appraise those damages. Now, if we're saying that we want to claw back, maybe they're saying, well, you got to appraise because you paid. We're not, that's a whole other can of worms. And Leeward Bay, in which the same circumstances occurred because they advanced payment and then later denied coverage, Leeward Bay did not distinguish all those other cases based on those facts. They certified conflict on the question of whether when an insured denies all coverage, appraisal is appropriate.
I'm sorry to interrupt you. Could you just sort of take a step back, though, and give us your take on what is the law that we're even supposed to be using as our baseline? Because it's an abuse of discretion question, right? In terms of what the trial court did, because after reading everything, I'm still not even sure, because it doesn't seem like the contract speaks to the order of things. We know we have law, and courts/juries decide coverage. Appraisers get to do the amount of loss, but to say that it's kind of per se unreasonable for a judge to allow the appraisal to happen and then sort of reserve the coverage thing for what's happening, I don't even know what I'm supposed to be looking at as the baseline to understand whether it's always an abuse of discretion in these circumstances to let the appraisal happen.
Well, I think what every court essentially has, the case they've interpreted is the Johnson versus Nationwide case, and through that also the Lycia case, both from this court. And they've frankly interpreted in different ways. They say it doesn't apply, or they say that it does apply.
Well, we would look at the Florida Insurance Code to see if there's anything applicable there, right?
You would, but there's nothing, nobody has argued that there's any applicable code provision that would govern these circumstances.
So then it's just a matter of looking at the insurance policy itself and following what it says, right?
Yes, Your Honor, and the policy itself, and this is on page 80 of the record, says, with respect to all persons insured under the policy, we provide no coverage for loss if, whether before, during or after a loss, any one or more persons insured have intentionally concealed or misrepresented any material fact or circumstance, engaged in fraudulent conduct, or made material misstatements.
Right, and then there's under paragraph 8, it talks about mediation or appraisal on pages 14 and page 14 of the policy, right? There's under the paragraph.
The appraisal provision?
It says mediation or
yes.
appraisal in the policy. Yes. Paragraph 8.
Yes.
And then in A, it talks about mediation, and B, appraisal.
Correct.
So far as mediation is concerned, is there a very specific provision in the Florida Insurance Code that deals with that?
Yes.
And that is 627.7015.
I'll trust your word on that.
Okay. There is a provision, subsection in there that talks about a definition of claim, 9B and C. B says it takes out of the definition of a claim where mediation would be required, where based upon agreed upon facts as to the cause of loss, there is no coverage under the policy. And then subsection C says, with respect to which the insurer has a reasonable basis to believe the policyholder has intentionally made a material misrepresentation of fact which is relevant to the claim, and the entire request for payment of a loss has been denied on the basis of the material misrepresentation. That sounds pretty familiar, right? That's what you're attempting to do here.
Yes.
Okay, so the legislature specifically has addressed a situation under this kind of scenario and has said that for mediation, 8A, that when that occurs, mediation is not required. Am I reading that correctly?
I believe so.
Okay, so
having not argued on either side, so in the trial court.
The way I'm looking at this is that that specific provision for the exception, that specific scenario, is not specifically spelled out in the policy, but it's still incorporated by reference as a matter of law, is it not?
Yes.
So for when we read this policy, by incorporation as a matter of law, that specific provision that you're attempting to exclude under the appraisal situation is there for mediation, but it's not there for appraisal. So why shouldn't we then conclude that the legislature knows how to do this under these exact scenarios and chose not to? And the insurance company could have specifically put that language in the policy, but chose not to. So why should we then read into the policy something that's not there?
I don't think you have to read anything into the policy except what's actually in the policy, which is on page 11, which is the concealment or fraud. That's all either party has argued, and in fact, both the insured and the second DCA have agreed that we have that coverage defense. That hasn't even been an issue in all of the litigation.
Right. So the issue is really not whether the coverage defense exists or not. It's just a matter of when can you bring that defense, and does it somehow prevent the appraisal process from going forward under the policy. So there's no language that says something like this. Something like this would have done it. We have a right to deny the claim for lack of coverage or fraud before there's an appraisal. That would work when we wouldn't be here, right? But that's not there. What is there is if there's an appraisal, we still retain our right to deny the claim, which seems to contemplate that there's going to be the appraisal process going forward, and you still have this right to deny the claim for whatever reason. So why isn't that why shouldn't we read the policy in that way?
Well, in terms of that appraisal provision, what that is, for example, in the Kiet Investments case out of the 3rd District, a 1997 case, where the fraud was not discovered until the appraisal process. And so that is a non-waiver of any fraud that may be discovered during the appraisal process. It does not override the concealment or fraud provision, which says that if we discover if there's any kind of misrepresentation, there's no coverage for the loss. You have to take those in paramateria.
Well, I don't think they're arguing that there's no fraud defense available. I think their argument is we should be able to follow what's in the policy and have an appraisal process, and you still get to assert your defense as well. Isn't that their?
That is their argument, Your Honor, but we believe that the court should follow the 4th District, which says that before you can determine damages, before you can determine the amount of loss, you have to determine liability. You have to determine coverage issues, because if there is no coverage, if there was concealment, then the whole appraisal process is moot. And
let me ask you this, counsel. It's hypothetical. Say where there's no appraisal provision, but everything else is the same. How's that going to be tried? You don't get a mini trial. Do you get a mini trial on your coverage before?
No.
Anything else happens, or is that just a defense that's tried as part of the whole trial?
Correct. It's a defense that's, and in fact, it was asserted as an affirmative defense. A jury trial was requested both in the complaint and in the answer on all issues so triable. And by the way, the complaint doesn't even request appraisal. The complaint is for breach of contract for denying the claim and for declaratory judgment. Nowhere in the complaint does it request appraisal, but it does request a jury trial. So yes, these issues would be tried to a jury. The jury would determine, A, were there misrepresentations, among other defenses that were asserted, like we don't cover tennis courts. And if there were no misrepresentations, then what's the damage to the plaintiff, to the insurer, just like any other insurance?
But all those issues would be tried to the jury, and then the jury would decide. And obviously, they would have some order of deciding things when they go back. But
exactly, yes.
It's not like you get a preliminary determination on the issue of coverage.
No. Your Honor, I think Justice Grosshans, I think you had a question.
I was just going to follow up on Justice Polston's kind of line of questions there. Wouldn't it, I know you're so excited to go back to that, wouldn't it seem that at the very least the retained rights provision would indicate that you can concurrently run a loss of coverage issue with an appraisal, amount of loss issue? Because you're retaining the rights to deny. I mean, there are certainly cases, correct, in which you've had this appraisal before you ever deny the claim, because you could demand the appraisal. The insurance company could demand the appraisal immediately, correct?
Yes.
So this happens.
When they admit that there's a covered loss, that there's some covered loss, that they're going to cover something, they may say, yeah, we're going to pay for your roof but not your windows. And in that case, I think everybody agrees there can be appraisal, and it can be first. But under Johnson, even though Johnson was a causation issue, Johnson approved of Gonzalez from the 3rd DCA, and Gonzalez says that when all coverage is denied, it becomes a legal question for the court to decide.
Right, but I don't think there's anything in the 2nd DCA's opinion that says anything different than that. And Johnson doesn't really demand it be in a certain order. I know that the Fourth interpreted Johnson to say that, but that's not really what Johnson says.
Ironically, the second DCA's opinion I believe it was Heritage, which is now a tag-along case here, said that when there is a denial of coverage, there is no appraisal. There's no appraisal, period, that a court cannot send the case to appraisal. And that's because under Gonzalez, under Johnson, it becomes a legal issue for the court. There's no coverage. We're saying there's no coverage whatsoever. That now is a legal issue that the court needs to decide. Because they denied appraisal, we're not operating under the contract anymore, under the policy. We're under whether there's coverage at all, and that needs to be determined by the trial court.
So, and that sort of gets to one thing that it seemed like there was kind of an ambiguity in terms of, it seems like in your brief you're arguing that once the coverage issue gets put on the table, that then it shifts everything over into the court arena, like the Chief was asking about.
Yes.
And that the jury would, and or the court would sort of decide both things together. But then I also, it seemed like in the cases there was kind of this assumption that, you know, sort of an acknowledgement that the court process would deal with coverage, but that the actual loss issues, if you were to lose on that and then loss, you know, the amount of loss became an issue, that the contract kind of gives you the, whoever invokes it, the right to have that decided by the appraisal. And so in that sense, the trial wouldn't really preempt the appraisal as being the way that the loss is determined, and which really does make it a sort of kind of more of an efficiency question of, is it worth going ahead and deciding the coverage first versus whatever. And it, so how do we, you know, is there kind of a clear answer on that, that once coverage becomes an issue that it necessarily kind of takes the appraisal off the table completely and makes the loss amount determination also for the court/jury?
I don't think the courts have spoken explicitly on it. A lot of the cases say something to the effect of the coverage needs to be determined before appraisal, but the actual directions really don't explain what happens on remand. I think the closest that a court has come to ruling, as I suggest, is ironically the second in the Heritage opinion, which is from February of this year, in which it was a supplemental claim. They denied the supplemental claim, and the court, despite the fact that it had decided Leeward Bay, it seemed to say, however, it said, however, when an insurance company wholly denies a claim, the trial court cannot refer that claim to appraisal. And then it said later, and since Heritage wholly denied coverage for that supplemental claim, Johnson and his progeny precluded the trial court from referring it to appraisal.
Yeah, and so I guess, and so that's my problem is, I mean, what part of the issue is, it seems like the courts that go down that path, in my view, are kind of over-reading Johnson. But do you agree that if you read the contract as giving the parties unilaterally to kind of invoke this right to have a dispute, almost like an arbitration type thing, to have a dispute over the amount of loss resolved through appraisal, then, and if we acknowledge the background principle that coverage is for the court, do you acknowledge that if we read it that way, that at the end of the day, once that's invoked, the loss amount is going to be determined by appraisal? Doesn't it just then become a timing question? It's sort of an efficiency thing, which brings me back to my initial question of, how could we tell a trial court that it's per se an abuse of discretion if it's just a timing question, to sort of do it one way or the other, as opposed to if making it a coverage, once you loop the coverage thing in, does that mean then that the appraisal is no longer available as a way of resolving the dispute over the amount of loss, if there is one? That seems like you're in a different posture then.
Yeah, that is our position, Your Honor, that appraisal becomes moot. But even if it's not moot, even if you say that that it'll proceed, certainly the damages cannot proceed until liability is determined. And in this case, and this gets into my second point, even if you're correct, or Justice Polston's correct, that appraisal can be ordered, it can go before, and it's discretionary, at least it should be exercised at the beginning of the case. Here, at the beginning of the case in December of 2018, the trial court denied a motion to compel appraisal. It was not until March of 2020, 3 weeks before trial, after 19 depositions were taken, after discovery, after proposed jury instructions, motions in limine, all that needed to happen was the trial itself. Then the court suddenly changed its mind based on a PCA citation opinion and said, no, let's go to appraisal. So even if they're correct and it's in the discretion of the judge, and it's not an abuse of discretion, that discretion has to be exercised at the beginning, not at the end, when any efficiencies have been eviscerated by then.
That makes sense to me, but they tried, right? I mean, they tried to get this done earlier on.
Exercise its discretion.
And not to do it, I mean, this thing got delayed, and so I agree with your argument that this should not have been delayed as it should have been, but so what are we going to do now? Punish them and not let them have the appraisal process that's provided in the contract at all because the judge erred? That doesn't seem like the appropriate relief.
But even under their theory, the judge did not err. He had the discretion, and he exercised it by saying no. So now he re-exercises the discretion after all that litigation had occurred.
You're saying that your client has somehow been harmed by the judge not doing this quickly enough. Is that what you're saying?
I'm saying that the judge exercised that discretion at the beginning when it should be exercised, and all of this litigation now eviscerates any efficiencies that can be obtained by appraising it first and determining what the amount of the loss is first.
Okay, counsel, as you know, you have exhausted all your time, but I'm going to give you 3 minutes for rebuttal.
Thank you for your generosity, Chief.
Good morning, Mr. Chief Justice. May it please the court. My name's Mark Boyle with the firm of Boyle, Leonard, and Anderson, along with Amanda Broadwell with Cody DeBost. We represent the Riverside. So the insurance policy in this case, written entirely by the carrier and with no contribution from my client, contains a unilateral appraisal provision authorizing either party to the contract to demand appraisal. As the court's already noted, the appraisal provision specifically contains the following term. If there is an appraisal, we retain our right to deny the claim. Every single court in Florida, the Middle District of Florida, certainly in this storm cycle, that has considered the issue we're here talking about today, whether this claim of fraud can bar going to the appraisal, has ruled in my client's favor. So if the standards, we would respectfully submit, abuse of discretion, every panel of the second district, there are dozens of these cases, as the court knows, parked here from trial courts who are dealing with these IRMA cases on a daily basis. They've all exercised their discretion in the way we're advocating for today.
I'm sorry to interrupt you. So if it happens the way you want, the appraisal process goes forward, and then that just kind of sits there pending the coverage issue being resolved by the court. And if the court says there's no coverage, then the appraisal thing was a waste of time. And if the court says there is coverage, then you just sort of take that off the shelf and plug it in as the amount. I mean, how does it work?
That's how it should work. And the court should have discretion. We shouldn't tie the court's hands about which one goes first. We're not saying that the trial court couldn't have. This came up with the second district oral argument. What if there was a claim of the fraud in the application for the policy, so the policy was void, or some other form of fraud that the courts thought strongly about should be tried first? We shouldn't tie the trial court's hand in evaluating this.
And so what's your position on this, on what the chief was asking and that I was asking about? Once you invoke the appraisal, does that take the amount of loss question sort of out of the court arena?
It does.
Okay.
And that's what the policy calls for.
So you disagree, so to the extent that the other side is saying that you sort of do the coverage and the amount together and the court sort of process kind of takes over what otherwise would have been done by the appraisal.
I didn't hear my opponent say that today, but that is their position. That is their position in their briefs. That's their position at the trial court. Once they raise this fraud issue, appraisal is completely off the table. Everything goes to the jury. That's their position. So the core issue, as I noted in this case, is the discretion.
Let me just ask you, you mentioned over here, you mentioned that that there'd be a basis for denial of coverage if there was proven fraud in the application process, correct?
That's correct.
And there are also many other bases for denial of coverage that have nothing to do with the disagreement over the amount of the loss, correct?
Correct.
Yeah, I mean, so with the judicially created rule that coverage issues come first, don't you think there's a distinction between coverage issues that have to do with anything else and, given the language of this policy, coverage issues that have to do with the amount of loss, because there is a contractual right to have that determined by appraisal?
So the broad answer to your question is yes. The difference in the application fraud that I conceded is, under Florida law, that voids the contract ab initio, so even the appraisal provision would go the way of the dinosaur. So that's different. But the court's correct. There are lots of there are lots of coverage defenses, such as there's a wear and tear exclusion that's being asserted in this case. That you appraise the case over that, and they can come back into court and make their arguments about the wear and tear exclusion. Trial courts are, particularly in my home community, Irma went right over this property here, and the Naples courthouse, they've become super sophisticated about letting the appraisal panel know what type of information they need to help them evaluate the coverage issues when they go back. Sometimes they ask for a detailed appraisal award, sometimes they don't. The courts know, the trial courts know how to deal with these problems.
Is your argument any different if Westin had sought the return of the money they had already paid out?
My argument would be that the policy contemplates this either way. It says we retain the right. But for sure, my argument's stronger, because this isn't a whole denial of coverage, irrespective of whether they're saying they denied the claim on a going forward basis. If in fact we committed insurance fraud, I would respectfully submit no reasonable person would not ask for their money back. This is not $4,000, this is $4 million.
So let me ask you though, so if we know that the coverage issue is going to have to be litigated no matter what, and we know that the amount of loss issue might go away if the coverage issue is decided adversely to you. So why would it ever be rational? Because at the end of the day, if it's an abuse of discretion, it still would have to be a reasonable choice for the court to bifurcate it and to have the appraisal proceed either concurrently or before. Why would it ever be reasonable to not start with the coverage, and realizing that the appraisals, if you're right, the appraisal is going to have to determine the amount of loss anyway, but it might not even be necessary at all. So why would a court ever say, no, I want you guys to go and do the appraisal and spend your time and money doing that, and then no matter what that, at least legally, I mean, the insurance company might go away, but at least legally, nothing that happens there can resolve the need for the court to decide the coverage issue?
So we have all been talking about, and my opponent speaks of the appraisal provision in terms of efficiency, but there's nothing in the contract that says this appraisal should only take place if it's efficient. It's a contractual promise. And Judge Lucas brought up with our second district oral argument that there's nothing textually about the provision that conditions it on the efficiency that the court is raising. And in fact, he said, and I agree with this, having spent the first part of my career representing the insurance industry, there's a lot of reasons the insurance company might have that provision in their policy. One of them is they might not want to visit with a jury about the amount of damages.
Well, but that's totally irrelevant, though. If it would be relevant if you were talking about taking away, about having the court sort of take over not just coverage but also the amount of loss. But if you take it as a given that if the amount of loss needs to be determined, that it will be done through the appraisal, that doesn't speak to why, from a timing perspective, why it would ever be reasonable. Because at the end of the day, this is the question. Could a reasonable judge say, no, I'm not going to decide the coverage thing first. I'm going to do what the party says and have them proceed together. I mean, can you respond to that?
Sure. I was going to get there to the end. I apologize. I wanted to set the predicate. The amount of time and effort, the trial court was well within her discretion to believe, and I respectfully submit correctly so, that the trial over the damages portion of this case was going to be the biggest part of the trial, and that sending this case to appraisal first would reduce the amount of trial time it took to try this case. I'm not saying there's no overlap. There is some, for sure. So there could be some inefficiency in having both proceedings go, but we shouldn't try the trial court's hand. The other thing I would note is that the trial court's docket, the chief asked a question about could we try the damages first in the normal case if this provision wasn't here. It's pretty unusual. I don't think I've ever been involved in it, but courts have the right to bifurcate matters all the time in their discretion. Sometimes we try liability first.
I think I was suggesting that you try the coverage first.
That's correct. I understood the court's question, but I would respectfully submit, even if what Justice Grosshans called the retained rights provision wasn't there, the trial court was within her discretion, and the trial court should be within their discretion to do that. And as the court noted, while the Fourth may think this court's prior cases tie their hands, there's nothing in this court's prior cases that speak to this issue. And if we raised a little bit of jurisdictional issue in our brief, as we did, all of the cases out of the Fourth, as best if you went through them, as best as I can discern, they're all cases where the claim never made it through the coverage grant or the insured didn't comply with some condition prior to appraisal. They didn't give an examination under oath. I would respectfully submit there is no conflict. This court doesn't need to address this issue. The Fourth has never treated this fraud issue.
Do the conflict cases have the same type language in their policies that deal with appraisal, or are there any differing languages?
All the ones that I saw had the same language. Some of the language is not in the cases, to be fair to the court, so it's not 100% clear. But this provision it's pretty close to the gold standard in almost all modern appraisal provisions.
Going to Justice Muniz's questions
meaning the retained
about
rights provision. I'm sorry to interrupt.
the questions about efficiency. For whatever reason, your client in this case chose you really want the appraisal, right? Instead of trying their fraud claim first, you want to do the appraisal and have it all done, I guess, at the same time. Why is that? Why is it somehow better for your client in this case?
I don't want to give the court my entire work product, but for sure,
maybe just a little bit of it.
For sure, the trial court may have understood that sending this case to appraisal would get it resolved. The only one of these cases, the case that we cited as the PCA that got the trial court to change her mind, and by the way, they didn't tell the trial court the first time she had discretion to send the case to appraisal. They told her she could not, and that's what she believed. So the court's correct. They led her down that path. But that case went back, it was referred to appraisal, and it settled it. It's not one of the cases that's parked here at the Florida Supreme Court. Part of the trial court's discretion should be to evaluate whether or not setting the appraisal first causes the matter to resolve. My overlying message, as I'm sure everyone can tell, is don't tie the trial court's hands with an artificial rule that's not called for by the policy or the contract.
That's the case. It's a dispute mechanism provision, right? I mean, that's what it's there for.
That's correct. And as one court recently noted, our system has, this is a quote, an overwhelming preference for the resolution of conflicts through extrajudicial means for which the parties themselves have contracted. This is all that we're here about. The appraisal process is strongly preferred. I should note, no carrier ever has to be in appraisal if they don't want to. There's nothing in the law of property insurance or statutes or the administrative regulations that require an appraisal provision in a property policy. Insurers typically put it in there. As I mentioned, Judge Lucas brought this up. They might not want to visit with juries, and that might be understandably so, and there's efficiency reasons. Better to have these, this is a multi-million-dollar claim, better to have it decided by construction professionals and people with adjusting experience.
And they could fix this issue if they wanted by changing their policy going forward.
To be more specific in the way the court noted, such as the mediation rule, or by having a bilateral appraisal provision. Those are quite common in the industry, where both parties have to agree to go to appraisal. and we have those cases cited in our brief. The carrier never had to be in this position. They're in complete control of the contract. Unless the court has any questions, I think the court understands our position.
Thank you, counsel. Rebuttal.
Thank you. It's not accurate to say that every court has held this way. Obviously, the 4th DCA has held in cases that denied coverage, that coverage issue has to be decided first. In the recent case in Merrick Preserve, where the court, where it was not a total denial of coverage, the court recognized that the conflict regarding when there's a whole denial of coverage still exists between the 2nd and the 4th. And in that case, in Merrick Preserve, said that in that particular case, the insured did not wholly deny coverage, and therefore that dichotomy did not exist, and said it was okay to send to appraisal first. But even in the 2nd DCA, the cases go a lot of different ways. In Leeward Bay, the court said that the trial court did not abuse its discretion in sending the case to appraisal. Then, in the Villaggio et Estero case, also from the 2nd DCA last year, the court actually said the court abused its discretion in refusing to send it to appraisal, and that the court had to send it to appraisal. So now, removing the discretion from the court and saying, no, appraisal has to come first. And then, as I said earlier, now you have the Heritage Property case from the 2nd DCA from earlier this year, which said that there is no appraisal if the insurance company wholly denies the claim. And so it's an issue that begs for resolution. We believe, to Justice Muni's point, certainly at this late stage of the case, there are no efficiencies. We're going to deny the claim no matter what. And now we can be prejudiced because the appraisal may be based on what we say are misrepresentations that aren't going to go before the appraisers. They're not going to determine credibility of witnesses. They're not going to cross-examine witnesses. They're not going to, most of them don't even have witnesses. And they may not itemize the damage. A lot of times the appraisers just say, this is the amount of the loss. So if you have...
Maybe I missed something, but you still have your coverage defense.
You do have a coverage defense.
And if you prevail on your coverage defense, that all just becomes totally irrelevant, right? That's part of your point.
That is.
So I'm having trouble seeing how you're prejudiced.
Because if the jury wants to award something less than that and say, well, you know, we claim that.
Well, that just means you lose on your coverage defense. I mean,
well, but the amount of loss is now, according to some cases, and this court can clarify, under the appraisal, that amount of the loss is now set in stone, and we cannot litigate damages in the trial court. So that amount of loss can be based on a misrepresented claim. That's the prejudice.
Well, and that's that's sort of the big lurking issue that it seems like there isn't clarity on. Is the appraisal just there to be sort of plugged in, or does the trial take that over? But so if you look at the 4th DCA cases, it seems like the two reasons that they give to support your position are the Johnson case, which, you know, I think it's overread, and then there's the Engel thing. I think we would have to have our heads examined to build out anything more on Engel. Sorry.
You haven't heard me argue Engel.
No offense to the court on that. I mean, so can you give us sort of a succinct, what would the reason be for us to say it's per se an abuse of discretion to handle it, to let the courts decide?
Very succinct, because I know I'm over my rebuttal time. Before you can determine damages, you have to determine whether there's coverage at all. You have to determine liability before you get to damages. You can't do it backwards with the tail wagging the dog and say that damages are determined first. Thank you. And thank you for your indulgence, Chief Justice. I ask for the reversal.
We thank you both for your arguments in this case today. The court will now prepare to take up the case of Summers versus the United States of America.
Thank you, Mr. Chief Justice. May it please the court. My name is Megan Salant, and I am an assistant federal defender in the Northern District of Florida. I represent Mr. Summers in the 11th Circuit Court of Appeals. The 11th Circuit has certified 2 questions to this court regarding Florida's simple assault statute. As to the first question, whether the first element of the offense requires a specific intent, all of the parties are in agreement that it does not. The statute creates a general intent crime. The only issue that remains in contention is what mens rea is required to prove the first element of simple assault. The first element of Florida's simple assault statute requires a voluntary act where the actor consciously disregards a substantial certainty that the victim may feel threatened. Simple assault can be committed recklessly. In Florida, recklessness is referred to as culpable negligence, or evincing reckless disregard of human life or the safety of others. Reckless behavior under Florida law is not merely voluntary behavior. It contains a component of knowledge. It is just not the heightened knowledge needed for the higher culpability standards of knowledge or purposeful. This court is consistent.
Counsel, I'd like for you to focus on the text of the assault statute.
Sure.
Which requires an intentional, unlawful threat by word or act to do violence to the person of another. Now, what does threat mean?
Well, threat has not been defined as it's
What's the
used.
common understanding of the word threat?
I would say it is a communication that is substantially likely to put the victim in fear, or the
Well,
listener in fear.
that's something I think you made up. Because if you look it up in the dictionary, it says something rather different. It says it is a communication, a communicated intent to inflict harm. That's one dictionary. Or it says a declaration of an intention to take some hostile action, especially a declaration of an intention to inflict pain, injury, damage. So built into that word threat, there is this notion of intent in its common understanding. Isn't that correct?
Correct. But what we are arguing is that that notion of intent is not as high as the knowing or purposeful standards of culpability. And that was established by the U.S. Supreme Court in Alonis. They made it clear that the definition of threat, according to the U.S. Supreme Court, does not necessarily exclude recklessness.
Well, okay, but what I think I'm hearing in the Chief's question is not like a gradient question, it's a round peg, square hole kind of thing. So to be reckless is to know a risk and disregard it.
Correct.
That seems different in kind, not in degree, from making unintentional communication. So I don't think, while I understand that mens rea operates and can be organized on a gradient, I think what you're hearing from the Chief's question, what you're hearing from me, is that it's hard to see how recklessness, which is about knowing and disregarding a risk, is compatible with the definition of the word threat, which is to make a communication of some kind. It isn't about ignoring a risk or being cavalier in the face of a risk. It's about making a communication. And for your theory to work, I have to make that communication recklessly, which doesn't seem to fit. Can you help me understand? What am I missing?
Well, I think that, so the example that I have found is in a crowded parking lot, if like an event ends and somebody goes to get out of that crowded parking lot and completely disregards the fact that that it is a crowded parking lot, and instead veers or screeches out of their parking space and puts all of those people, affects all of the people who are in that parking lot, all the pedestrians. That person is putting those people in fear. And when you read the statute as a whole, when you read it together with the third element.
What was the threat there?
That they were going to get hit by the car.
Well, no. But what threat did the defendant? I understand, but I guess to push back on your hypo just a little bit.
Sure.
Help me understand how that conduct is similar to the conduct in this case. In that, here I think the defendant engaged in threatening behavior with a victim in mind. I'm not sure that what you're talking about is what I would charge or what they would charge as an aggravated assault, right?
Well, first of all, in my case, we're not looking at with the facts of Mr. Summers' aggravated assault. We're only here to consider the statutory elements.
I
of
got it,
simple
but
assault.
I'm responding to what you're giving me as something that makes your definition of threat work, and my response is I don't think it works.
Okay. Well, I believe that when you read the statute as a whole and you realize that there is a very strong victim component in the third element.
But that's just a separate element. I mean, it is true that is there, but that's a separate element that has to be satisfied in addition to the threat element.
Sure. And our argument is that the threat has to be an intentional act that would put the victim in fear.
So, counsel, under your sort of theory here, and following up on Justice Coriel's hypo, if someone was driving recklessly, and there was no doubt it was reckless driving, which is its own crime,
correct,
and someone was in fear that they were going to be harmed through that reckless driving, could that person also be charged with aggravated assault with a deadly weapon?
Yes. Okay. So I also think that
Let me ask you this, and this is, I don't think anybody's thought about this, but we have a statutory rule of lenity in our criminal code, and it says the provisions of this code and offenses defined by other statutes shall be strictly construed. When the language is susceptible of differing constructions, it shall be construed most favorably to the accused. Now, I understand this is kind of an odd situation. It's kind of like we have a role reversal here, but obviously we have to look at this from the perspective of a prosecution for this offense.
Sure.
And I just don't understand any way that there's not an interpretation, a reasonable interpretation of that offense, which is going to require that there be a direction of a threat at a particular person, which is what is required, if I understand Borden correctly. Is that consistent? I mean, because all of this, we talk about specific intent, general intent, all that. Borden didn't talk about that, did they? I mean, they didn't talk about specific intent.
No.
So tell me this: what are we looking for under Borden? What do we need under Borden?
Well, I would propose that you don't need anything under Borden, because the point of this is for you to decide what the Florida law, how the Florida law applies.
But the question is, how does that fit within the Borden framework? That obviously is the question that the 11th Circuit wants us to address.
Well, of
they
course.
aren't concerned about how the particular terminology that we use in Florida law. That's, because in this context of the law, these terms are used in different ways in different places, and it's kind of a quagmire. But so you don't think we really have to figure out how this fits, how our statute fits within the framework under Borden?
Well, I think the 11th Circuit has asked you to identify what the mens rea is for this offense, and if they knew if they could clearly tell from the case law and the statute what that was under federal law, then they wouldn't have asked you to address it. But I do believe that.
I understand it's a question of state law that we need to address, but it's a question of how the state law fits within the framework under Borden. Or am I entirely missing something when I think that?
No, that's correct. I think that under Borden, what you would need to decide is whether or not this is an offense that can be committed recklessly.
Okay.
That is the language that Borden uses, and that is sort of the bright line rule that Borden established. So, and I think that this court has said again and again that a reckless violation of another's rights is actually an intentional violation. It said that in Cannon, Preston, Savage. There's a number of cases where this court has held that. And what they're protecting against, what it seems to be protected against with this statute, is the public's right to not be in fear, to not be, worried that at any moment someone's going to pop off with a gun or back into them with their car or something like that. And since this court has said that sort of reckless violation is intentional, then I would assert that the assault statute is a reckless statute, the simple assault statute, excuse me.
Let me ask you just a question. something that I observed a long time ago when I was a prosecutor. I was watching a trial, and the prosecutor in the case, it was an armed robbery with the use of a firearm. It was a big .357 Magnum. I think it would require both my hands just to pick it up. It was a very violent robbery. People were pistol whipped and so on and on. The prosecutor, in closing argument, picked up the gun that was in evidence, walked up to the jury, cocked it, and pointed right at the jury, saying, "This is what it feels like to have a gun pointed at you." Obviously, there were all kinds of emotions, but would that qualify under your hypothetical of there having to meet some type of intent? Would that be reckless on the part of the prosecutor, or would that qualify as an aggravated assault?
I think that would come down to a question for the jury as to whether or not if that was a reasonable action.
Good answer.
I would certainly have been terrified and
obviously
angry.
Obviously, the jury was
right. Right.
But in this instance, the talking about the mens rea, obviously he did not intend. Well, he intended to frighten them, obviously, but not the intent that I think is required for a crime.
Right.
But by the same token, it seems like all the elements of aggravated assault were there.
Correct. I think that, like I said, I think that when it comes down to it, it would have to be a jury question whether or not that was actually a threat. But it doesn't seem reasonable to me.
Well, it didn't work. The guy was acquitted.
Maybe it's because they were mad at the prosecutor. So the DCA cases in Florida here have discussed that what's necessary to prove simple assault is actual intent. And the difference between what we're claiming and what the Solicitor General is that what that actual intent is. So we're, like you said, we're taking it as a degree of awareness, that the actual intent is, it's a degree lesser than the knowledge and purposeful requirement, which would make it recklessness. And as I said, because
So to agree with you, we would have to decide that this ordinary definition of a communicated intent to inflict harm is not what threat means.
I think that Florida would have to be recognized as an outlier for that in the assault statute. Yes.
So well, I'm not sure. So we'd have to reject that definition.
Yes, I think that we'd have to have the element, the word actually defined by this court in the statute, as it's used in the statute, which we don't have.
But we've got it defined in multiple dictionaries.
Well,
what I guess my question is, we'd have to reject, to accept your view, we've got to reject the definition that appears in multiple dictionaries.
I think that you don't necessarily have to reject it. There has to be an understanding that the intent is not one of the higher levels of intent. In that definition. It's not the most culpable element. It's not the most culpable mens rea. It is one below that. All right. I'll save the rest of my time for rebuttal. Thank you.
Good morning. May it please the court, my name is Jordan Learn. I'm an assistant United States attorney in the Northern District of Florida, and I'm here on behalf of the United States. We're asking the court to hold that the first element of simple assault in Florida requires a purposeful or knowing threat of violence against another person, and that a reckless threat, a threat made recklessly, is insufficient to trigger culpability under the assault statute. Now, unless there are any...
Let me ask you this. So that makes sense to me when we're talking about a verbal threat, a threat by word. I mean, I don't see how it couldn't be directed at a person to meet the definition of the statute. But what about the threat by action? There are plenty of cases in Florida, probably today, maybe one's being tried, where a suspect is fleeing law enforcement in a vehicle, and there are officers either in a vehicle or on the just standing that are in the way, and they'll jump out of the way. And then if the state believes that that can be that it can be proven that there's an intent that's directed at a person, they'll charge attempted murder. With the aggravated battery with a deadly weapon charge, the vehicle being the deadly weapon would be the lesser included offense. But if they don't, they would charge it based on what I would think would be reckless conduct, that it's aggravated assault with a deadly weapon. So how is your statement true when the threat is by act? Isn't it possible that that is reckless?
Sure. No. The answer is no. If it's a reckless threat, then it doesn't qualify as a threat under the statute. The question, I think what your question is focused on, is going to turn on whether or not the defendant is substantially certain that his actions would be perceived as a threat of violence. And so we see this in Swift and Pinckney's very similar factual circumstances. And Swift actually reversed an aggravated assault conviction essentially because there was insufficient evidence that the defendant had insufficient evidence that the defendant could be certain that his action would be perceived in a threatening manner, because he didn't realize that the officer was in his path when he was reversing the vehicle. So it's going to turn on what circumstances do we know the defendant's aware of, and whether or not the defendant is substantially certain that his actions will be perceived as a threat. And that is analogous to knowledge under the Model Penal Code.
But under Borden, aren't we talking about an intent to direct the action at a specific person?
Sure. And so,
and in the hypo that I was using with the car, it is impossible that they would meet the definition of the statute, aggravated battery or assault with a deadly weapon, without intending to direct that at the specific person.
Our answer would be no. If there's not a sufficient evidence that a defendant is substantially certain that his action is going to be perceived by another person as a threat, then that's insufficient evidence of mens rea under the statute. And that's essentially what happened in Swift. There was insufficient evidence of knowledge, and so they reversed that aggravated assault conviction.
So in my example, the prosecutor was definitely reckless.
Sure.
In pointing a .357 Magnum at the jury 3 feet away from them, but he intended to scare them. So where does that fall?
Well, if it's an intentional, if he's acting with purpose, then we would say that certainly qualifies.
So he could have been charged with what, 7 aggravated battery?
Aggravated assaults.
With a firearm, 3-year mandatory minimum each.
Right. I suppose in theory, yes. But I also think if you apply a knowledge standard to that, you're going to get the same answer. If you point a gun at somebody, you can be substantially certain that the person on the receiving end of that gun is going to interpret that action as a threat. And that's all that we're saying the statute requires. So
say I have a gun here and I pick it up, I just recklessly just swing it around and I see everybody out there just bending over. Does that mean I just committed aggravated assault on everyone? I
think that's certainly a tougher question. I think under the reasoning of Pinckney, yes, that could be charged as an aggravated assault, and it would just be a jury question of whether or not you were substantially certain that your action, based on the facts and circumstances in which it occurred, was reasonably likely to constitute, to be perceived as a threat. And that's all that we're saying the standard is. Certainly it meets the standard of reckless. You know, I could see argument both ways, and it'll come down to a factual jury question, but we do think that the plain language of the statute compels at least a minimum standard of knowledge, and that comes from the word intentional. Under well-settled Florida law, intentional means substantially certain. When you act, you are substantially certain that the criminal result will be achieved. And so that's a knowledge standard. It's analogous to knowledge in the Model Penal Code. And when you pair that with threat, the only possible interpretation is that you're acting with substantial certainty that your action, whatever it is going to be perceived by a person as a threat. And we think that's the only interpretation that is consistent with the plain language of the statute. If the Florida legislature wanted to have a recklessness standard and the assault statute, they could do that if they wanted to. Georgia has done it. They wouldn't use the word intentional. They certainly would not say intentional threat. They would say either reckless, which appears in other Florida criminal statutes, or they would use the culpable negligence standard, and it's just not what they've done here. So we really do think this case should begin and end with the plain language of the statute. We think that the first element is clear. It's at least a knowledge. We say purpose or knowledge is what we're asking the court to hold, and that's just because the higher mens rea of purpose includes if you act knowingly, if you act purposefully, then you've also satisfied the element of knowing under just well-settled principles of criminal law. And I should add that every district court that has actually focused on the language of the first element of Florida assault has agreed with this interpretation. They've applied a standard that's analogous to knowledge, and like I said, they've looked to see whether or not the defendant acted with substantial certainty that his action would either elicit fear or be perceived as a threat. And where they find that evidence lacking, they've reversed the convictions without hesitation.
Let me go to the nonverbal examples that Justice Lawson was talking about. What about you cut somebody off in traffic? One car really cut somebody off in a very abrupt, threatening sort of way. And the driver who has been cut off feels threatened by that. Is that enough?
No, because that's focusing on the victim's perspective. The first element of assault focuses on the defendant's intent and whether or not he was substantially certain that his action would be perceived as a threat. I think there too, if you're just dealing with, sort of aggressive driving, you might also run into issues about whether or not that even meets the definition of a threat. The common definition of a threat is an expression of harmful intent.
What does the defendant have to do in order for it to comply? I mean, flipping them off, is that enough? They flip them off and then cut them off?
No, sure. The state would just have to point to circumstances that would demonstrate the defendant was substantially certain or practically certain that his actions were going to be perceived specifically as a threat. So
that would be enough?
I don't think that would be enough. I mean, it's going to depend on whether or not there's sufficient inference. I don't think aggressive driving would be enough. Different cases will present different circumstances, and there will be things you can point at. But I think you're going to apply a knowledge standard, and it's going to depend on the defendant's knowledge.
When was the last time you drove on the Florida Turnpike?
It's been a while. It's been a while. But we do think a knowledge standard can be imparted meaningfully into the statute. And like I said, even if this court thinks that it would result in anomalous sort of applications, based on things that happen in traffic, you're still obligated to apply the plain language of the statute. We think the plain language of the statute is abundantly clear. The only interpretation that's true to the words the legislature passed is that it's an intentional threat. So that's at least a knowing threat. A reckless threat, if there's insufficient evidence of knowledge, then you haven't committed, and the government can't prove it, then you haven't committed an assault under Florida law. I'm sure there's other things that could fill that void, but it's not an assault. And so, unless the court has any other questions, again, we're asking simply for the court to hold that an assault in Florida requires at least a knowing or purposeful threat of violence directed at a person, because that's what Borden and that's what the 11th Circuit cares about. We think that's plain from the language of the first element in the statute, and that is simply that a threat committed recklessly is just insufficient as proof for culpability under the statute. Thank you.
Mr. Chief Justice, and may it please the court. If the court has no questions on the first certified question, I think the case then comes down to, is this a purpose crime or a purpose and knowing crime? And in the state's view, it's the latter. The word intentional, when the legislature used that phrase in 1974, according to Professor Lefebvre, was well accepted to mean both the purpose to accomplish the prohibited act as well as the knowledge that the result would be substantially certain to result. And so we think, as the legislature used that term in the mid-70s, it encompassed both of those concepts. It did not encompass recklessness. So further support for that idea comes from the U.S. Supreme Court's decision in U.S. Gypsum Co., where the court explained that purpose and knowledge are encompassed by the idea of intent. And the reason for that is because whether it's your conscious objective to achieve a prohibited result, or you simply know that it's a substantial certainty that the result will occur. You've acted wrongfully in the eyes of the law, and so it's fair to penalize that individual.
So the purpose you're talking about, the purpose is to place the person in fear. That's the purpose of the act.
I'm not sure that would be the purpose. The purpose would be to convey a threat, which, as the Chief Justice pointed out, would be defined as a communicated intent to threaten. But I'm not sure that you actually have to have any kind of specific intent to put the person in fear. It would be enough if you had as your objective the purpose to make a threat. I think there is a distinction there.
If jokingly pointing a gun at somebody, you may think you're joking, but the victim doesn't think you're joking. Where is the purpose there?
So the purpose there is the communication of the intent to threaten, and I think that's what's required. In any event, though, under our view of the mens rea here, that kind of threat would be covered because either it was your purpose to communicate the threat to do violence, or you knew that it was substantially certain to result. Now, in your example earlier with the prosecutor in front of the jury with the firearm, the answer there might be that there is no ultimate liability, either because there's not a well-founded fear or because...
Spoken like a true prosecutor.
Well, I mean, it may be that in the confines of the courtroom, it's not well-founded for members of the jury to believe that that's a communicated intent to threaten. So that may be the answer to the hypothetical. But in any event, we don't believe that recklessness rises to the level here. And I would point the court to pages 10 through 13 of Mr. Summers' reply brief, because the way in which he articulates the mens rea that he thinks applies to the intentional threat prong, we just view that as being knowledge, at least as articulated by Florida law and the Model Penal Code. So when you talk about a substantial and unjustified risk, all the commentators in courts have said that that's a recklessness standard. It's about risk. But when you talk about certainty, which is the way that Mr. Summers himself defines the mens rea here, a substantial certainty or a practical certainty, we think those are synonymous. When you talk about a certainty, that's a knowledge standard. I'm happy to answer any additional questions the court may have. Thanks for your time.
Rebuttal.
All right. So just to respond to a few of the points made by each of the governments. I think one thing that seems confusing is that the definition that the Chief Justice identified has the word intent in it, and then the statute also has the word intent in it, or it has the word intentional. And I just want to make clear that word intentional in the statute, as the courts have identified, does not link to the word intent in the threat definition that the Chief Justice read. That just determines that it is a voluntary act, one that is being doing deliberately. It distinguishes it from, as many of the cases have said, it distinguishes it from being strict liability or something that somebody does involuntarily. Also, to point out, I just want to point out, in Borden, it was only the plurality that said that the threat was a use of physical force against another. It wasn't the majority. Justice Thomas dissented on that point, and his analysis, where he did join the plurality, but he did not join the majority. He said he was focusing on whether or not the use of physical force, has a well understood meaning applying only to the intentional acts designed to cause harm. So he was not saying that he did not agree that the definition of threat included that it had to be purposely targeted towards another person. I think it's also important to note that the elements of simple assault have not changed over time. They didn't change. They were the same. The court identified them as the same before codification and after codification. And as old as the Peterson case from 1889, this court identified that the aggravated assault conviction could be upheld because there was clear evidence that the defendant acted deliberately and recklessly. So that definition has carried on. And if there are no other questions, that's all I have. Thank you.
All right. We thank all three of you for your arguments in this very interesting case. And the court will now be in recess for about 10 minutes before we take up the last case on today's docket.
All right. Supreme Court of Florida is now in session. Please be seated.
We now take up the case of Statler versus the State of Florida. Counsel?
Good morning, and may it please the Court. My name is Megan Long. I'm with the Public Defender's Office for the Second Judicial Circuit, and I represent the petitioner, Mr. Statler. Your Honor, I would like to reserve 5 minutes for rebuttal, please. Thank you. Your Honors, my client, who was a college student at the time, was convicted by a jury of sexual battery on a person over age 18 years. He challenged that statute in the First District Court of Appeal in a facial constitutional challenge because it does not contain an element of mens rea. The First District Court of Appeal expressly held that the statute is valid. Today, we are asking this court to find the statute unconstitutional because it violates due process without a criminal intent element, or read that into the statute. And for my client, we're asking this court remand to the lower court and discharge his judgment and sentence, or if this court thinks there was a jury question, remand back to the trial court for a new trial.
Sorry to interrupt you. So I understand that it wouldn't necessarily take care of the sort of statutory interpretation questions on the kind of at the front end of the statute. But if we were to agree with the state that consent, is an objective concept and that the absence of consent has to be objectively manifested in order for the state to meet its burden, does that take care of the constitutional part of your argument? Would that solve the due process problem?
No, Your Honor.
And why is that?
When we look at the evidence here, and I'm referring to the briefs on the objective consent standard, the alleged victim, actions, words, the other evidence as to consent, that could be objectively met. My client could still have no criminal intent, and it's still unconstitutional. And that's why, if the state is not proving that my client had criminal intent during the act, it doesn't cure that constitutional defect.
But isn't that tantamount to sort of a negligence-based mens rea functionally? I mean, and obviously there's no law, there's no precedent saying that negligence-based criminal statutes are unconstitutional as due process violations.
Is my argument that this should be a negligence? My argument
well, I'm
should
saying
be
that if you accept what they're saying about the consent having to be objective, one way of reaching that result would be to sort of build it into the definition of, the mens rea on the front end, or if you just really treat the consent element as a completely separate thing and just look at it objectively, you arguably end up in the same place. And so why wouldn't that? I understand that it still doesn't tell you if that's the right way to interpret the statute, whether it's on the front end or on the back end, but doesn't that solve the constitutional problem?
I respectfully disagree, Your Honor. So consent is defined in the statute knowingly, intelligently, voluntarily. If there's evidence that the alleged victim, under an objective standard, was showing consent or lack of consent, there's still absolutely nothing that requires the state to prove beyond a reasonable doubt my client or any criminal defendants what their intent was. And here, this is a case, and I won't go into the specific details, they're covered extensively in the brief, where the defense could have argued if the jury looks at this and under an objective standard finds she didn't consent, they could still believe my client if the state had to prove intent beyond a reasonable doubt. So not only could my client's theory of defense been something that the jury could consider and find valid, but also that she did not reasonably consent. That was taken away from the jury here, and that's why without that, the specific element of mens rea, for a crime that, this is a serious consequence. This is a second-degree felony, and my client went to prison. He could not be here today because he's still on sex offender probation, and the terms and conditions, he couldn't come up here and attend this court argument. And lifetime sex offender registry. If you're subject to those restrictions and you don't do it, it's a felony, and it's scored as such on the score sheet that
let me ask you this.
It's prison.
The victim obviously testified during this trial. Did she testify that it was not consensual? That she consented to Mr. Tate, but not this second guy?
That was her testimony, Your Honor, that she consented to sexual intercourse with Mr. Tate, and only later realized that my client was not Mr. Tate.
Was it not then a jury question as to whether to believe or not?
The consent, or her lack of consent, element number 2, we would argue that the trial court got the judgment of motion for judgment acquittal wrong. We think there's enough evidence there that shows she did consent. But if this court thinks it is a jury question and it properly went to the jury wasn't allowed to consider his mental state at all. And that's why that ruling was there in the JOA. And I would note, that's what the prosecutor focused on in this case. The prosecutor said in closing argument, the most important thing for you to focus on, and of course what the prosecutor says isn't evidence, but it's meant to guide the jury. What you need to focus on in this case is that consent is only from her perspective. You can't consider what Mr. Statler thinks. That's what the state wanted the jury to focus on.
Your position, your defense was that from his perspective, he was under the impression that it was okay with her.
Yes, Your Honor.
And how did you go about proving that? Did he testify to that effect?
He did not testify, Your Honor. Again, the defense doesn't have to put on any evidence. We don't have to prove anything.
I understand that, but how would you ever drive that point home to the jury?
Well, for one, if the court had allowed or had granted the defense attorney's request for intent to be an element, I'm sure the closing argument would have changed in this case, and the opening statements as well, where, say the jury, if you believe the alleged victim and you find her testimony to be credible, you find that 911 call to be credible, you can still believe my client's theory of defense, that he, when he went into that bedroom, didn't know that he did not have consent. Both of those could be true and acquit my client. And again, that's what the prosecutor focused on, and what the trial court, too, remarked at sentencing, said this wouldn't be a crime in other jurisdictions, and of course gave my client a below the guideline sentence. So in terms of evidence, we don't have to provide anything, but I do think the trial counsel's argument would have been different, and certainly if that element were in there, Mr. Statler committed the act without the consent of the alleged victim and knew she did not consent. That's what the defense would have focused on here, and maybe hammered that point more on cross-examination of the alleged victim, and certainly the defense did present some evidence in the witnesses in the parking lot that showed his belief as to her consent, and the interaction in the parking lot, the interaction in the apartment, certainly during the sexual intercourse and right after.
Can we just go to the statute for a minute?
Yes, sir.
What's your best evidence, looking at the plain language of Section 5B, that either person, the defendant or the victim's state of mind, is itself an element, and what kind of element it is? Like, can we just engage with the statute for a minute and tell me what your best evidence is?
So when I look at that statute, it's without the consent of the victim, and consent is defined as knowing, intelligent, and voluntary. There's absolutely nothing as to the defendant's mental state.
Okay, so can we agree then that on the face of the statute, what is at issue is an objectively knowable jury question? Does consent exist or not? That's really the element, right?
That element number 2? Yes, Your Honor.
Okay. So then, following through to that, in this case, as in many others, the jury will always be presented with facts that they need to decide, whether they support a finding of consent. And here, your client could have said, hey, when he walked into the room, right? Didn't. Could have said what his name was, could have identified himself, and instead this jury made the very permissible finding that he was trying to pull a fast one. I mean, isn't that just a clear application of the mechanics of the statute to the facts at issue? And what am I missing here? Like, isn't that exactly the elementary sort of sorting that a jury is supposed to make and allowed to make?
I have a couple of responses, Your Honor. The first one is the jury under this statute considering the consent of the victim or alleged victim? Yes.
They're just determining whether or not consent existed. It's an objective fact for them to determine under the plain terms of Section 5B, right?
Yes, that's a fact. But there's absolutely nothing about what my client's mental state was. And yes, I acknowledge that.
Where is that in the statute? It's not there, right?
It's not, Your Honor. What I am asking for, the second remedy, is for this court to read it in, as in Giorgetti or Ciccone, or more recently, I would, and I would say this court has the inherent power to do that, Article 5, Section 1, and I would more recently.
No, go ahead.
I would more recently argue to this court's opinion in Gaiman. I will supplement the authority after this argument. But so if there's not something in the statute that and it's unconstitutional, that's our position. This court has the inherent authority to.
I'm glad you raised Giorgetti, right? So let's say we agree that Giorgetti is, sort of requires us to see a mens rea unless there is and we can put this in a separate box, a strict liability sort of treatment, right? So if we agree with you that Giorgetti requires us to find the existence of some mens rea, why does it have to be specific intent or indeed anything other than just treating it like a general intent crime? Because it sounds to me like in order for you to win, we need to sort of Giorgetti our way not just into a general intent crime, but also like a very specific sort of state of mind on the part of the defendant.
Well, we are asking for a subjective standard, but even under an objective standard. And adding an element of that the defendant knew or reasonably knew, if it's an objective standard, that the alleged victim did not consent, that would cure the constitutional infirmity. And I think in Justice Lawson's opinion in Gaiman, that should be used very sparingly, but this court also has a duty to uphold the statutes that the legislature passes if there can be a constitutional way to save it. And as in Gaiman, I think that applies here today, where clearly the legislature wanted non-consensual sexual relations between two people over 18 when everyone is capable of giving consent to be a crime. So, again, our first argument is you should strike it if you don't think that an intent element can be put in there. But I would say under Gaiman, everyone can win here. There can be, the statute is upheld, this court can make it constitutional, but it can also protect due process rights of defendants, because for defendants in this position, they believe they have consent, there's evidence that the alleged victim consents, they don't have a defense. There's no mens rea, there's nothing in there, and they're not able to present that to the jury and again, the question's not, was my client or any defendant in this situation, were they making wise choices, these college students that night? It's, did he act with criminal intent? Was this a felony? And the jury didn't get to consider what his mental state was. And again, that's why what we're arguing is adding a mens rea element for this serious felony would cure that constitutional infirmity, keep the statute as written by the legislature, honor the intent of the legislature, but also make this comport with due process.
Changing the facts, I think the first guy told your client to go on in, right?
Yes, sir.
What if the first guy had said, go on in, she said it was okay, and was a little more clear about that? And does that, under the statute, she still would not have given consent, therefore he's guilty, right?
You're saying if she had told Mr. Tate
if the first guy said, go on in, she said it was okay, when in fact she didn't.
She can't give, the person, Mr. Tate can't tell my client that she gave consent, is what Your Honor is getting at.
Say it again?
Mr. Tate can't go out and tell my client, this alleged victim gave me consent to tell you. That's Your Honor's.
Well, I think he's asking if that had happened.
If that had happened.
If he had done it, you still wouldn't have her consent. Nothing changes on her part. But now this message has been conveyed to him. What happens in that situation?
Your Honor.
Thank you.
Your Honor, in looking at these facts, I submit that already happened here. My client, when Mr. Tate came out, regardless of whether he didn't say what Justice Polson said, my client believed he had consent based on what Mr. Tate did say, and based on the prior interaction in the parking lot. What Justice Polson said, if he'd come out and said that, my client would be in the exact same position, because he believes, and again, this isn't about whether any of this was a good idea, he believes he has consent, and certainly...
Well, for purposes of understanding how this statute works and whether it's constitutional or not, if you made the facts a little more extreme, where he was specifically told, yeah, she said it was okay, when in fact she didn't, then under the statute, he's guilty, right?
The statute, but even under Your Honor's hypothetical...
Is that right? Under my facts, he would still be guilty, even though he believed, based on what the first guy said, that he'd been given consent, when in fact she hadn't.
But under the statute, it's a question for the jury, and the jury wouldn't be able to, is not able to analyze it. So different facts, same statute, there's no mens rea element. So for people in my client's position raising this argument, no matter what the facts are here, this is a very unique set of facts. Maybe not all cases would have the jury struggling with intent and consent in the way that the jury may have here. But no matter what the facts were, even if they're worse to the client or better to my client, that statute doesn't have any mens rea, despite it being a very serious statute. And so we are asking for this court to exercise its inherent power, add it in there, and make it constitutional.
Doesn't everybody agree, though, that there's a mens rea in the sense that, at least as to what you're calling the first element, the committing sexual battery, that has to be intentional, right?
Yes.
Okay.
The act of union or penetration, but in a case like this.
But I'm trying to act. This might help you. I mean, so why would and the word intent isn't in the statute there, right? That's just sort of a background kind of understanding that it's a criminal law. There's no sort of evidence that it's meant to be strict liability. There's an intent for that part. So why would you artificially stop there and not include within what would have to be intentional the having the quote-unquote sexual battery without the person's consent? Why wouldn't that? Isn't that sort of your best kind of textual argument?
This court should add any and all words to the statute to knowingly
or
without intent.
I wouldn't characterize it as adding words to the statute.
Or adding any words that would eventually be in a jury instruction. So yes, so in these cases, so element one, where identity is not a defense, my client's not disputing that there was sexual union penetration. It goes then to element two, consent. And what we're asking for is knowingly. And if this court sees fit to add any more requirement, that would wind up in a jury instruction. But as it is, there's just no defense for adults under this statute. It effectively requires affirmative consent to engage in sexual intercourse with another adult in the privacy of the home.
Right. Well, I mean, I think that goes back, though, to this question about consent and whether you just look for objective manifestations that a reasonable person would construe as consent. I don't think that you need to go as far as requiring quote-unquote affirmative consent to get to that definition that the state is proposing for that.
Well, I would say under the facts here, my client had the evidence here in this record shows that the alleged victim, there were acts and words that showed affirmative consent. Of course, that changed at trial, and the jury believed her testimony. But again, as the prosecutor and the court.
This would be an entirely different case if when your client went into the bedroom, the victim turned around and said, "Come on over." Wouldn't that be an entirely different case? Because that would be an objective manifestation, given all the attendant circumstances, an objective manifestation that she consented to having sex with him.
Yes, sir.
But that's not what happened.
Correct.
That is not at all what happened. And so there's no, there is no objective manifestation that the victim here consented to sex with the defendant. He tries to talk about things in the context which she refutes. And so it's just a totally different, and it would be a totally different situation if he had spoken to her and gotten her attention, and then she had invited him to come to come on in the room. But that's not what happened.
That's correct, Your Honor. But what I would say is this. Under these facts and circumstances, it's the jury's opinion that counts, and the jury didn't get to make that call in this case about whether he had criminal intent when he went in there. And of course, I would also say this: he didn't turn off the light. He didn't conceal himself anyway. The light was on. If we were going in there to commit a crime, this was a college student. This was a young man with no criminal record. I submit the facts would have been different when he went in there, but he believed he had.
You have exhausted all your time. I will give you 3 minutes.
Thank you, Chief Justice Kennedy.
Mr. Chief Justice, and may it please the court, in our view, knowledge is not required here, and that's plain from the text and context of this law, longstanding Florida case law, and common law tradition, all of which show that in the unique context of rape, Florida law has always dispensed with knowledge requirements, and so this is not at all unusual. I'd like to start by answering one of Justice Muniz's questions about how is it fair to read into the statute a voluntary act requirement, an intent requirement to commit the sexual battery, but not a knowledge requirement as to the intent and circumstance of consent. We think the explanation is a historical one. At common law, it was always the case that if you did not act voluntarily, you did not act at all. So if I had an involuntary muscle spasm, the law considered that not to be an act. That was something entirely different. And so we're not disputing that that's been carried over into the statutory version of this offense. So it's fair to read that in because that's inherent in the common law. It's not fair, however, to read in a knowledge requirement based on all of the arguments we've brought to bear. So if I could go to text and context, many of the cases that my friend relies on are cases where all the government or the state had to go by to support its claim that knowledge was not a requirement was the statute's silence. There simply was no stated mens rea in the offense, and courts said for various reasons, well, we'll read one in. This is not that case because it's not just that the statute doesn't explicitly require knowledge. It's that there are so many other textual indications, including in this very statute in subsection 4, that show that when the legislature wanted to require a mens rea here, it just went ahead and said so.
But can I ask you about that? So you agree that the first, if we start with 5B, with regard to the sexual battery part, that has to be intentional, right?
It has to be a voluntary act, right?
Okay. So why do you, so the statute, as you know, defines sexual battery as to just mean the contact. There's nothing in the so every act of consensual sex meets that definition, right? And what brings it over into the sort of culpable criminal realm is the without consent. Right. So why is the act not the contact and the without consent part? Why is it right to separate those two things instead of viewing them as one, when the alternative is to basically, because you're calling the consent part a quote unquote intended circumstance, which I think is atextual in connection with 4, because 4 talks about the contact without consent, and then it says in the following circumstances. So it seems at least textually the legislature isn't viewing the consent as in the basket of attendant circumstances. It's arguably the act itself. So why doesn't the voluntariness transfer into having sex without someone's consent, as opposed to just having sex?
So I think the answer is it's just in terms of how the criminal law ordinarily categorizes elements. So there are 4 types of elements, common elements that we talk about in criminal law. There's the actus reus, there's the mens rea, there's causation or result, and then there are attendant circumstances, which are facts that surround the circumstances of the crime that make it criminal. And so
the act, but is it normal for the act to be something that's just completely morally sort of neutral? I mean, here the act, because you're saying the criminal actus reus is just the sex, right? And that then the lack of consent is just sort of an add-on attendant circumstance. It's like the gun. It's like having a gun within 1,000 feet of a school. You're comparing the consent to like whether you're near a school or not.
No, but I think
right.
Exactly. But I think that's a useful example. Say, take felon in possession. It's ordinarily not criminal to take the actus reus of possessing a firearm. That's the actus reus. It only becomes a criminal act when the attendant circumstance of being a felon is also present. But we would not say, I think, that the actus reus there is being a felon in possession. We would say it is the possession of the firearm.
Well, let's try something a little closer in the text of the statute. So statutory rape, I think you would agree, but tell me if you wouldn't, can be committed unwittingly, right?
Right.
Okay. Can this crime be committed unwittingly?
Yes, in the same way.
Help me understand.
So in both, it's not unwittingly in the sense that you can't realize you're taking the act of sexual intercourse, but it's unwitting in the sense that the attendant circumstance which makes that sexual intercourse unlawful, you do not need to know of. And so I think that's another good comparison. The law has always said that if you engage in sexual intercourse and you simply don't know that your partner was underage, we're going to hold you liable for that. I think this is a particularly good example because the reason that we have statutory rape laws reflects a societal judgment and the legislature's judgment that some people are too young to form valid consent. And so in the statutory rape context, age is really just being used as a proxy for is there consent. And the legislature decided that as a matter of law, if you're 15, you cannot form consent. So the point is we've never required knowledge as to age, which is the same as saying we've never required knowledge as to consent.
Well, but I mean, see, that's where I think the historical stuff isn't as much of a help to you as you make it out to be in the briefs, because we obviously have this long tradition of kind of special protection for children. We have the traditional definition of rape, which required force, which signals to a person if you're having to use force and overcome someone, they don't have consent. And so now you've basically turned your interpretation of the sort of the minimal sort of lowest level rape statute in Florida, you've turned everything into the equivalent of old statutory rape, in the sense of you do it at your own peril if down the line objectively someone decides that there was an absence of consent, just like objectively it turns out that the person who you slept with was younger than you thought they were, if you cared.
Well, I think as it turns out, the potentially harsh results of statutory rape as to age, for the reason that you've already explained in your questioning, doesn't apply with the same full force here, because a defendant in Mr. Statler's position gets the benefit of the objective nature of consent. And so even if he did not actually know, he certainly reasonably should have known, and thus his conduct is not innocent. Now, if you go to the statutory rape context, which is useful but distinct, there, if you have a 16 or 17-year-old boy or girl with a fake ID who misrepresents his or her age, that's a far harsher result, but one that our law has always embraced. But in any event, again, this is not a case where it's just a question of statutory silence. And the reason I think that subsections 4E, 4, and 5 are helpful is because they are aggravating circumstances where the legislature said if this is going to be aggravated from a second-degree felony punishable by 15 years to a first-degree felony punishable by 30, we're going to require some additional knowledge as to an attendant circumstance. So when the legislature wanted to require knowledge, it simply said so, and that's true of various other provisions in Chapter 794 as well.
Can I ask you, I think it's going to be very important, whatever the court decides here, in terms of, especially if the court decides to go down the path of describing consent as a subjective thing, it's obviously going to be very important how that's described. And it seems like in your brief, you offer sort of a couple of different formulations. And in one formulation, you talk about sort of this obligation that that the defendant would have had to, quote unquote, obtain consent. And then in other formulations, you talk about looking at all of the circumstances objectively. Could any reasonable person have believed that there were manifestations of consent? And it seems like there's certainly, at least in the real world, I mean, the former sounds like a kind of campus code of, asking, getting permission for each thing. And the latter sounds more what I think would be consistent with sort of a more kind of person in the street sort of common sense way of understanding it. So which one are you arguing for?
So we think it's the latter. So it's the objectively reasonable person knowing all the circumstances. And I think that has to be true because there is not consent in Justice Polson's hypothetical, where a third party relays to someone like Mr. Statler, which are not these facts, but relays to someone like Mr. Statler that the victim is willing. So we think that there's liability there. But there's still...
You would certainly find liability, right?
There is certainly liability there.
Even though it was like the unintended circumstance.
Right. Yeah, that's our view of how that would work. So it's not the reasonable person in the defendant's shoes. It's the reasonable person knowing all the facts. So hopefully that's helpful in drafting the opinion. But I think largely we still get all the benefits, for the most part, 99 add a whole lot of nines % of the time. That defendant would still have reasonably known because he or she was there and is going to be aware of almost all of the circumstances.
Well, the knowledge would be imputed to them. So do you agree, one of the cases you rely on is this Kaspersky case in Nebraska, and they cite favorably from the New Hampshire case where it says that the victim must manifest her unwillingness objectively. And then it talks about the victim objectively communicates lack of consent. Would it be a mistake for us to characterize it that way?
We disagree with those statements because what's required for the element of non-consent is simply that there not be consent. So you do not have to resist, you don't have to say no, you simply have to not consent.
There just has to not be consent, if I could editorialize what you just said.
I think that's fair.
Right. And would the jury be told that that the prosecution has to prove beyond a reasonable doubt that no reasonable person viewing this constellation of circumstances would believe that there was consent?
Well, but I don't think it needs to necessarily be part of the standard jury instructions.
Well, no, but I mean, if that's what, I mean, because you want the juries to know, I'm not putting aside whether it shows up in the book and whatever, but if someone asks for an explanation of it, is that what the explanation would be?
I would phrase it a little bit differently. So I don't think it would be, no reasonable person. I think judges would properly instruct juries that consent is present when a reasonable observer, knowing all of the facts, would conclude that the victim had exhibited a willingness to have sex.
Well, but that's, I mean, I'm trying to figure out sort of the overlay of the beyond a reasonable doubt standard onto that. I mean, because you know what I'm saying?
Just tack it onto the front. A jury would have to find beyond a reasonable doubt that no reasonable observer knowing all the facts would have found that there was consent.
Okay.
But at the end of the day here, I think what's animating a lot of Mr. Statler's concerns is the idea that we're going to be criminalizing, innocent conduct. But the legislature here reasonably made the policy judgment that there was nothing innocent about having sex with a person where you haven't had a modicum of concern about whether they in fact consented. And so the incentive structure that the legislature created here makes a lot of sense because the least a person can be expected to do when they engage in the enormously consequential act of sexual intercourse is to confirm that they in fact have a willing partner.
Yeah, I mean, and you say that throughout the brief, but it's kind of a question-begging thing in the sense, I mean, it sounds like what you just articulated would argue for sort of a recklessness that would make it a mens rea or recklessness and not even have it be this objective thing. I mean, obviously, the point is, this whole case is about how would you prove that there was an absence of consent. Nobody disagrees that that's relevant and that it's immoral to have sex without someone's consent. It's a question about how do you prove that?
Well, I think it's evidence of, what the legislature did here, and it's an explanation for why the legislature intentionally did not include a knowledge requirement or a recklessness requirement even. Can I address any other questions from the court? Thank you for your time.
Rebuttal.
Thank you. I'd like to respond briefly to a few of my colleagues' points. First one is the legislature didn't explicitly take mens rea out, didn't put anything in the statute when they've been updating it over the years that says mens rea is not an element of this offense. The second point I would like to make is sex crimes involving minors is completely irrelevant to this court's analysis. I don't think this court consider it. And the third one is going back to Justice Curiel's question, can a person commit sexual battery under this statute unwittingly? Yes, the way it's written. That's what happened to my client. What we're dealing with is, and I use these terms because this is what the legislature said in 794.005, the basic sexual battery statute, the quote, least serious. That's how the legislature defined it. And for defendants in my client's position and others, there is no defense if they believe they have consent.
Okay, but let's play that out. So you'd agree with me that the statutory rape laws, which allow convictions of somebody who's unwittingly engaged in sex with a minor, those have survived constitutional challenge, right?
Yes, sir.
Okay, so what makes this different then?
We're dealing with adults.
Yeah, but
there's not going to ever be, I'm sorry.
Help me understand how that changes a constitutional analysis from the standpoint of whether mens rea is required as a matter of due process.
We're talking about a victim who society has says cannot consent, a minor child, and here we have an adult who's not physically incapacitated, any of those other things that are in the statute. When we're talking about two adults over 18 who can consent, this can criminalize innocent conduct, and so that's the difference, and that's why a jury needs to make that call. Now, a jury may look at the facts of this case if it were remanded and could consider intent and fine for the state, but they might not, and they didn't get to make that call here.
How do you answer your the state's argument that indeed it isn't innocent conduct because of the absence of consent, much like, for example, it isn't innocent conduct for the felon to be in possession of the firearm under 922G because, we've said that if this additional, condition is present, it is not innocent. Okay, so what's your answer to that?
We're talking about adults, and here, my client with no criminal history, adults engaging, adults who have the capacity to consent, engaging in private sexual activity in the home. Under this statute, if someone believes they have consent, the jury doesn't get to make that call. And so we would submit that is a due process violation, and we do submit that violated my client's due process rights. I do see I am out of time, so if there are no further questions I can answer for this court today, I would conclude by asking this court to strike or find this statute unconstitutional or require a mens rea element, and my client is seeking a new trial if this court thinks that it properly went to the jury on JOA. Thank you.
We thank you both for your arguments in this case today. The court will now be adjourned for the day.
All rise.